Okay, we're starting today Perek Gimel of Sanhedrin, Mishnah Aleph. Perhaps we'll get also to Mishnah Beis. So let's remember that when we began the Masechta in Perek Aleph, the Mishnah listed the sizes of the courts, the number of dayonim that are to be on each one of the Batei Dinim needed to judge different categories, different cases. Now, because in Perek Aleph we encountered that the Mishnah spoke about Kohen Gadol, so in Perek Beis the Mishnayos went on to discuss various laws of the Kohen Gadol, as well as laws relating to another one of the great leaders of Am Yisrael, the Melech. Now we come back in Perek Gimel to discuss, to learn the subject that we found in the first Perek, and that is the various categories and mechanics of each of the Batei Dinim, starting with the Beis Din of Shlosha. So the Mishnah begins by quoting the very first words of Perek Aleph, Dinei Mamonos b'Shlosha. Monetary cases in Yonim of Mamonos are judged by a Beis Din of three, by a court of three. Now, how are these three Dayonim to be selected? How are the three Dayonim appointed? How does it come about that these three individuals now serve on a Beis Din? So the Mishnah tells us, Reuven and Shimon have a machloikes regarding mamonos, regarding damages, regarding an injury. So one is teveya, the other to come to Beis Din. He's making a claim. You owe me $100, you owe me $1,000, you owe me $5,000 of damages. So this is dinei mamonos, and they come and they are to be adjudicated in a Beis Din of three. How do these three come about? Says the Mishnah, Ze boirer lo echad, v'ze boirer lo echad. One litigant, Reuven, selects a dayan for himself, and Shimon, the other litigant, selects one judge for himself. Ushneim boirim lo enod echad. And these two litigants, Reuven and Shimon, together they select one more judge for themselves. Now it's important to understand that a judge, that a dayan who is chosen by a given litigant, will make sure that this dayan chosen by Reuven, fully understands, fully comprehends, fully is aware of the complete position, of the thorough position of that litigant. He will do his best to find out all the circumstances, all the arguments, all the halachas, all the facts that support the litigant. And he will then be able to present them efficiently, systematically, thoroughly before the Beis Din. The second judge will do the same for his litigant, for Shimon. He will also find out all the details, all the circumstances, everything that he needs to know in order to fully comprehend his litigant's position. So in this way, no point that could support either litigant will be overlooked. And then the third dayan, the one who, according to Rab Meir, is chosen by the two of them. Rab Meir says, so the third judge listens to the discussion between the first two dayanim and decides which one is right. So according to Rab Meir, this is the best method to make sure that the correct verdict is reached. This is Shitas Rab Meir. Ze borer lo echad, ze borer lo echad, u'shneim borer lemod echad, divrei Rab Meir. V'chachamim omrim, and the chachamim say, shnei hadayonim borerim lo echad. It's not the litigant who chose the third dayan. It's not the litigant, but it's the first two judges who select one more judge for them, right? The svara of the Chachamim is that if the two judges select a third judge on their own without the involvement of the litigants, so then the third dayan is less likely to lean towards the position of either litigant. Very important point that the Chachamim are making. That the two litigants can't choose the third, because the third can then perhaps be somewhat more inclined towards one of those who chose him. And therefore the Chachamim say, no, the third judge should not be more inclined towards any one of the positions, and therefore he should be chosen by the two dayanim. The previous Tana Rab Meir agrees that the third judge is selected by the other two judges because they must consider him worthy of serving on the court with them. But the machloikes is the dispute concerns only the involvement of the litigants. Rab Meir holds that the litigants also have a say in selecting the third judge, while the Chachamim maintain that the selection is made exclusively and entirely by the first two dayanim and not by the litigants at all. So that was the first machlokes in the Mishnah. How do the three dayanim come about? According to Rab Meir, ze borer lo echad, ze borer lo echad, v'shnei borer lo echad. And according to the Chachamim, shnei dayanim borerim lohem od echad. Now comes another machlokes between Rab Meir and the Chachamim about the selection of dayanim. Says the Mishnah, ze poisel dayana shel ze, v'ze poisel dayana shel ze. One litigant can disqualify, which means can refuse to accept, the judge selected by the other litigant. And the other litigant, Shimon, can disqualify the judge selected by the first litigant, by Reuven, Divrei Rab Meir. These are the words of Rab Meir, meaning to say that Rab Meir allows a litigant to reject only a certain type of judge, namely one who is not fully knowledgeable, one who's not fully aware of all the implications in the law, but whom the public has accepted and authorized to serve as a judge in their community. So according to Rab Meir allows the litigant to reject only a certain type of a dayan, namely a dayan who is not fully knowledgeable, but whom the public, the tzibur, has accepted and authorized to serve as a dayan in their community. A regular judge, however, cannot be rejected even according to Rab Meir, where the Chachamim say, the Chachamim oimrim, Eimasai. The Chachamim say, when can a litigant disqualify a judge? Eimasai, when can a litigant disqualify a judge? Bizman shemevi alein raya shehen kroivim upsulim. When he can cite proof that the judges are related to each other, or to one of the litigants, he's a koroiv, or that they are otherwise ineligible to serve on the court. Right? In other words, that they're disqualified to serve on the court because of one of various disqualifications that are discussed in Mishnah Gimel and Dalet. But if they are eligible to try this case, or if they are experts, Eino yochal leposlan. The Chachamim say, Eino yochal leposlan. A litigant cannot disqualify them from hearing the case, which means that the Chachamim's words should be understood to mean, but if they are eligible, they must be treated like experts, the Rav says. That is, if the judge is eligible, he's not a relative, he's not otherwise disqualified, he cannot be rejected, just as an expert cannot be rejected. Meaning to say that according to the Chachamim, since the judge was appointed by the public, the tzibur has accepted him by everyone. All of the tzibur accepted him as a legitimate qualified dayan. So a litigant cannot simply refuse to accept him because he doesn't like him. The only way to have him removed is to prove that he is ineligible. He is disqualified. He is possible for one of a number of different reasons. Right? Again. אבל אם היו כשרים ומומחים, אינו יכול לפוסלון. If they're eligible, they cannot be disqualified, say the Chachamim. Now comes along another machlokes. Rav Meir and the Chachamim disagree whether in a particular set of circumstances a litigant can disqualify witnesses. Again, the machlokes coming up is whether in a particular set of circumstances a litigant can disqualify witnesses brought by his opponent. Says Rav Meir, ze poisel eidav shel ze, v'ze poisel eidav shel ze. One litigant can disqualify witnesses brought by the other litigant, and the other litigant can disqualify witnesses brought by the first litigant. So says Rav Meir. What is Rav Meir saying? That this ruling applies in a specific case, namely where one litigant said that two groups of witnesses will come to court and testify for him, even though we only need one group of witnesses. If one kosher set of witnesses come, that's all we need. But he said that two sets of witnesses are going to show up. So after the first group of witnesses appeared in court, the second litigant, together with another man, testified that those witnesses are disqualified. They're psulim. Because, for example, they were related to each other. Therefore, they're posel le'edus. So in this situation, even if the second litigant succeeds in disqualifying the first witnesses, he will not win the case because another group of witnesses are coming to testify against him. So since the second litigant has nothing to gain from disqualifying the first witnesses, his testimony against them is believed. Is believed. Now the Chachamim disagree. The Chachamim disagree. The Chachamim say, Emasai, when can one litigant disqualify the witnesses of the other? Bizman shehu mevi aleim raya shem koevim upsulim. Only when he brings proof, besides his own testimony, he brings proof that they're related to each other, that they're koevim, or they are otherwise ineligible to testify. They're psulim. Avalim hoyu ksherim, eino yochol lepoislon. But if they are eligible to testify, he cannot disqualify them through his own testimony. Since even in the case presented before, it is possible for him to gain. It is possible for him to gain from disqualifying the witnesses. He might be biased against them, and his testimony is therefore rejected. Which means that according to the Chachamim, a litigant is never required to bring more than one set of witnesses. Even if he said that he has two groups of witnesses and then brought only one, the group that he does bring does not lose its credibility. They are credible. They are believed. They were kosher witnesses. They're fine. In the Mishnah's case, therefore, even if he fails to bring the second group, he could win his case based on the first group of Eidim alone, since the verdict, the Psak Din, could very well depend on the first group. His opponent may be biased against those witnesses, and therefore his testimony against them is invalid. So explains the Rav. Okay?